Confused about U.S. immigration? Or unsure which path is right for you? At Raju Law, we guide individuals, families, and businesses through complex U.S. immigration matters with clarity and confidence. Led by attorney Raju Mahajan, our experienced immigration attorneys share practical insights, real solutions, and up-to-date guidance you can rely on. Join our free online session every Monday at 11 a.m. Eastern Standard Time, where our attorneys discuss key immigration topics and answer your questions live.
Hello everyone and warm welcome to Rajulo Mondays Live. I'm Ms. Faral Dushari Turin and I will be your host for this session. Today's topic is especially important for multinational companies, executive, and families exploring the L-1 and L-2 visa categories. L-1 and L-2 explain executive transfers and immediate spousal work rights. A quick heads up for all the viewers, we will be sharing our weekly immigration news update at the end of the session. So be sure to stay with us till the very end. To guide us through today's discussion, we are joined by our guest, Kathleen Moran, Associate Attorney and Team Lead Raju Law.
Hi, good morning. How are you today?
I'm doing very good, Ms. Moran. It's wonderful to have you with us. How are you doing?
I'm doing well. I'm very excited to do today's session.
Great. That's great to hear. Our audience is very eager to understand how L1 executive transfers work and how L2 spouses can benefit from the immediate work authorizations. Please go ahead.
Perfect. So as I said, today we're going to be talking about the L1 and L2 visas, how it works, and what your spouse will be able to work as well. So what is the L1 visa? I know a lot of people are curious about different ways to come to the U.S. through the employment-based route. So the L1 visa is a non-immigrant visa that allows a U.S. employer to transfer either an executive manager or an employee with specialized knowledge from their foreign office to the U.S. So again, focusing on that non-immigrant visa. So this is always a non-immigrant intent, meaning that the intent of the employee should always be to return to the U.S. after their time in the U.S. is done, whether for their assignment for that duration. It's always to return back. It's not an immigrant visa. So it's a very useful tool for multinational corporations. We'll get into the L1 blanket visas later. It's also useful for small startups and other appropriate businesses. And there are some instances where the L1 visa holder can come to the U.S. to establish a new office for the company, but we'll get into more detail on that as well. So again, I've kind of touched on it, but there is a difference between the L1A and the L1B. So the L1A is for executives and managers. So employees that are working in a managerial or executive capacity, it allows the L1A visa holder to come for initial stay of 3 years, but can be extended up to 7 years. There's also the L1A when they're coming to set up the office. That petition, they only allow the L1A visa holder to come for 1 year, and there are special circumstances that they can extend. But for a new office, they want to make sure that the office is going to be, profitable and successful, so they only allow them 1 year. But again, there are 2-year increments for extension, maximum of 7 years. That's all for L1A. For the L1B, this is not for executives or managers. This is for employees who have a specialized knowledge. It could be specialized knowledge concerning something within the field or perhaps the company's products, techniques. They have maybe a specialized knowledge in a research capacity. So again, there's no managerial requirement for the L1B, but there is a maximum initial stay of 3 years. Again, 1 year for that new office, but it can be extended up to 5 years. And for the L1B, there's also the perm labor certification requirement, which makes it a little more difficult as well. The key requirements for either of these L1 types of visas, there's a qualifying corporate relationship, they have to be doing business, and there's 1 year of qualifying foreign employment as well. So we'll get into what all of these mean. For qualifying relationship, so the U.S. employer, the U.S.-based, I should say, employer must have a qualifying relationship with the foreign office abroad. So there's different ways that this foreign office and the U.S. employer can be related. It could be like a parent company, whereas one owns at least 50% of the other. There could be a subsidiary, same thing, just reverse ownership. It could be a branch of the same office, or it could be an affiliate. So that means that both offices are perhaps controlled by the same parent, individual, or group. A key distinction is that the foreign and U.S. entities don't necessarily need to be in the same business field, right? There are many multinational corporations that have other smaller offices that aren't necessarily all doing the same thing, but that's still applicable for the L-1 visa. And what does it mean to do business, right? Mostly it comes down to having more than just a presence, more than just an office space in the US or abroad. The definition of doing business is the regular, systemic, and continuous provision of goods and or services by a qualifying organization. So again, this applies to both the US and the foreign entities for the duration of the employee's stay. So if perhaps they are doing business and then later the foreign entity closes or just becomes more of that open office space and that isn't really doing business, that makes that L1 invalid, right? It does not include the mere presence of an agent or an office without active operations. So our practice tip is that even if the US entity only provides service internally to the foreign parent, it can still be considered doing business, right? It doesn't necessarily have to be open and doing business with customers in the US as long as they're still helping and working with the company abroad. And there's also the requirement of 1 year of foreign employment. So the L1 beneficiary must have worked for the organization abroad for at least one continuous year within the 3 years immediately preceding their admission to the US. So it couldn't have been that they were a wonderful employee or executive manager 10 years ago, right? And then they haven't worked for the company in the last 3 years. That won't work. They have to have been working for at least one continuous year within the immediate 3 years before they apply for the L1. Which I shouldn't say apply, before they're admitted on the L1. And this employment must have been full-time. Part-time work will not qualify. And also want to note that brief trips to the US, maybe for business or pleasure, perhaps you came on a business tourist visa or something, that doesn't interrupt the continuous 1 year as long as you're still employed in that full-time capacity for the foreign entity. So again, what does it really mean to be the L1A managerial or executive capacity? So managerial capacity, this is perhaps someone who manages the organization or a department, subdivision or function. They're supervising and controlling the work of other supervisory, professional, or managerial employees. So this is a good distinction because they're not supervising entry-level workers, right? Or people maybe who don't have that specialized knowledge. They're supervising maybe other managers or people who do have that specialized knowledge. They have the authority to hire and fire or recommend such actions. Again, they have a lot of responsibility. This isn't a entry-level role, I would say. Crucially, a first-line supervisor of non-professional employees is generally not considered a manager. So like I said, right, if you're managing a small team, and none of them have or maybe they're not crucial roles or they're all entry-level employees, that won't reach the threshold of a managerial capacity. The executive capacity, think of this as like a board, right? So they are directing the management of the organization or a major component or function of the organization. They're establishing the goals and policies of the company. They have that discretion to make the exercise the wide latitude and discretionary decision making, and receives only supervision from higher level executives or board of directors. So this is really at the top of the company when we mean executive. Managerial, a little below them. And again, getting into the L-1B specialized knowledge, what does it really mean to have specialized knowledge? So the Immigration and Naturalization Act, the INA, defines two types of specialized knowledge. There's first special knowledge, which is knowledge concerning the company's product, service, research, and its application in the international markets. That is distinct or uncommon. That's a crucial note because if this is kind of knowledge that everybody in the field can have, then there's no reason to do an L1B for it. There's also advanced knowledge, which is knowledge of the company's processes or procedures that is greatly developed and not commonly found within the relevant industry, right? It would be onerous to hire somebody else and to have the same experience and knowledge that this person with advanced knowledge has. So the L1B is necessary. Another key points, the knowledge does not have to be proprietary or narrowly held within the company, right? So there can be quite a few employees that have this knowledge, but it doesn't make it any less special or advanced just because you have employees within the company that have it. It's about looking at the field broadly. Yeah, exactly. The test is whether the knowledge is so common in the industry that is no longer specialized. If you could hire anybody in the foreign country or in the US that would easily have this knowledge, it's not going to meet the threshold for the L1B specialized knowledge. This is really people who have the advanced knowledge that is necessary for them to come to the US and to do this work. There's also the special case, which we sort of touched on, which is the new office petition. So if a business is doing the new office petition, they have been doing in the business in the US for less than 1 year. And like we said earlier, initial petitions for the new office are approved for only a maximum of 1 year. The requirements for the new office petition are a solid business plan for the next year, sufficient physical premises that have been secured, so showing proof of a lease, a purchase agreement, something of that nature to show that you actually do have a physical space for this office to be established. and the U.S. entity is or will be a qualifying organization with the one abroad, and that the petitioner has the financial ability to compensate the employee and begin doing business. So showing tax returns, bank statements, things of that nature to show that you really do have the financial ability to begin this new office. So let's say that we've already been past the first year or coming up on it and they want to renew, right, to have their employees stay longer. What you need to show, or what the business will need to show for their L1 staff, is that the U.S. entity has been actively doing business for the previous year. So again, showing the tax return, showing payroll, again, showing the office space, all these things to show that it has been profitable and successful over the last year. Also showing the staffing is now sufficient to support the executive or managerial position. So perhaps you want to bring in an L1A, showing that your staff has grown over the last year will be able to help establish that. And that also showing that you've been sticking to the business plan that you submitted a year ago, right? If there's been sufficient deviation from that, if you're not reaching goals, that will be less likely that any kind of extension will really be approved. There's also the special case, the blanket L petition, also sometimes called the LZ. This is when a single petition will pre-qualify an employer's U.S. and foreign entities. So this allows, like, let's say a large multinational corporation, if they are doing, 10 plus L1 visas a year, it's quite a lengthy process to get all these approved when they've already shown a need, that they have the staffing and then they're doing business and everything, and they need these people in the U.S. quickly. So to be eligible for this, this type of entity has to be engaged in commercial trade or services, have the U.S. office doing business for at least 1 year previously, and have 3 or more domestic and foreign branches, subsidiaries, or affiliates. So again, showing a wide network. And they have to meet one of the following. So obtained at least 10 L1 approvals in the prior 12 months. So again, showing that there is a high need for these employees, or have U.S. affiliates with combined annual sales of at least 25 million, showing a profitable business, or have a U.S. workforce of at least 1,000 employees, which really shows that you do need the L1, the L1A managerial or anything to be able to properly supervise these employees too. So how it works is that once the blanket L is approved, an employee can apply for an L1 visa directly at a U.S. consulate using Form I-29S instead of the typical Form I-29, which is submitted for the L1s. Instead, they can go directly to the consulate in the foreign country and apply there, which is a much smoother process than having to wait for the USCIS processing. So getting into the forms a little bit more, we have the I-129 and the L supplement. The Form I-29 is a petition for a non-immigrant worker, again, stressing the non-immigrant intent of this form. So this is the core form for all the individual L1 petitions. When looking at the form, Part 5 is really critical, as it will detail the proposed employment, job title, and wages. And there's also the L classification supplement to Form I-29, which must be submitted. This is a mandatory form for all individual petitions. And this will include the detailed description of the beneficiary's duties abroad and in the U.S. So very clearly showing what their duties are, what the relationship between the foreign office and the U.S. office, whether that's a parent, a branch, a subsidiary, affiliate. This is where we're kind of getting at those 3 core requirements, is detailed in the L supplement. And a lot of people are wondering whether if they come on an L1, will their spouse have the right to work? Which is yes. So L2 spouses are authorized to work immediately upon admission to the U.S. They don't necessarily need to apply for an employment authorization document. I do think it's helpful to apply for an EAD, so they have another form of ID, but it's not a requirement under L2. So whenever they enter, CBP will issue an I-94 record with the code L2S. For I-9 verification, they can use that unexpired I-94 to show their L2 status, which will serve if you need to begin employment or for tax purposes, have that valid List C document for employment eligibility. And in terms of Social Security numbers, they can use their L2 I-94 to apply for a Social Security number if for payroll purposes. But it's important to note that children on L2 status do not have the authorization to work. Now getting into common triggers for RFEs and denials for L1 petitions, L petitions in general. Again, listing on the form ambiguous job duties. If you are not clearly listing how this employee is, how their role is primarily managerial or executive or requires specialized knowledge, it's going to fail, like the 3 requirements that we discussed. Also having weak evidence of a qualifying relationship. These things will issue an RFE clearly, because if you're not providing any kind of documentation or enough documentation of the ownership and control between the foreign entity and the U.S. office, it's not going to be enough to convince the USS officer that this is really a need. Insufficient doing business proof. So this may be things of lack of ongoing active business. So again, showing like things like payroll, tax records, any other proof that the company is making business and is profitable, those are showing that you're actively doing business and not just renting an office space in the US or another country. For new office sufficiencies, failing to show sufficient physical premises. So this is, again, for people who are coming to do a new office in the United States, having a virtual office is a red flag, because if you don't have the physical premise, if you don't have that requirement, then it's not really necessary for you to even bring these employees over to the US. So also not having a viable business plan or adequate funding will be red flags. Having the L-1B knowledge not truly be specialized, so a petition can fail if they don't properly differentiate the beneficiary's knowledge from that commonly held by others in the industry. So if you could hire anybody in this industry and they would have this knowledge, it's not going to be enough to qualify for the L-1B. So key action steps for our clients: designate a point person, because USCIS can do site visits at these companies. So if you have somebody, for example, someone in the HR that's trained to handle the USCIS visits, it'll go much more smoothly and be a little less scary for everybody involved. Being able to verify the credentials is also a crucial step. So if somebody from USCIS comes to a site, make sure to ask for and record the officer's name, title, and contact information, whatever they can give you. Keep the petitions accessible if you have L1 employees. So have copies of all L1 petitions readily available. Again, I think this is a better role for somebody in HR. And always answer truthfully. If instruct managers and employees to confirm details like their job duties, work location, and salaries as stated in the petition. I feel like sometimes they might be afraid and will embellish their details in order to seem more important or have more knowledge than they actually have, but that will almost surely backfire. It's not necessary. They just need to be truthful in what they're actually doing, what they're really being paid, and where they actually work, right? So in these instances, it's always better to state whether you're unsure rather than providing an answer that you're not sure of, and that could be incorrect and become a problem later on. So if you're working with our firm, we always recommend that you have this designated person call us as soon as the site visit begins so we can guide you through that. And for best practices for L1 success, I always recommend front-loading the evidence and assuming that every case will be scrutinized. Under this current USCIS landscape, it seems that they're being much more stricter with a variety of cases. So if you have the evidence, don't hold back, right? We also understand that, officers may not have a lot of time to review every petition, but much better to put forth all the evidence we have rather than hold anything back and then provide it for an RFE, right? We want to build a strong record as possible, showing that everything we need for the L1 petition is already established. Also, a petition should sell a story, right? That's how I think we think across all of our immigration petitions, that it should clearly explain what we're trying to show. So for L1s, we want to clearly explain that the business need for this employee in the US is crucial, right? What does this employee have that others in the field don't easily have? Also defining the role precisely. So like we touched on a little bit earlier, being as detailed as possible, right, for what the duties are, whether it's trying to reach the L1A or the L1B capacity, you really need to show what exactly they need. So using percentages where possible, for example, like 30% financial oversight to prove that the position meets the L1A or LB standard will be more helpful, being as detailed as possible, really. Also educating the clients, in this term we mean like the business entity. So preparing them for the entire process, especially for regarding new office requirements and the possibility of a site visit, as those things can be scary if you're not ready or you're unprepared, right? So double checking the details, right? Ensuring corporate relationships are correctly identified and all fees are calculated correctly. So if you're interested in doing an L1 visa, please reach out to our team. We have our phone number right here. We're also easily available online. You can look through our website for the variety of immigration support that we offer. And we have our email right here as well. So please reach out to us if you're interested in doing the L1 pathway, and we'd be happy to help.
Thank you, Ms. Moram, for that insightful presentation. We will now take a brief break of exactly 1 minute and 11 seconds. Please stay tuned as the session will resume shortly.
Are you an extraordinary individual looking to take your talents to the land of opportunities? Welcome to Raju Law, your trusted partner in the pursuit of the American dream. The EB1 category is designed for individuals with extraordinary ability in sciences, education, arts, business, athletics, or any professions, as well as for outstanding professors, researchers, and multinational executives or managers. This includes individuals with a record of sustained national or international acclaim, and those who have achieved significant achievements in their field. At Raju Law, we specialize in guiding extraordinary individuals through the complex EB-1 application process with ease and efficiency. We will evaluate your unique qualifications and determine your eligibility to secure this highly sought-after immigration preference. We'll highlight your awards, publications, media recognition, and other evidence to establish your extraordinary ability or outstanding researcher status. Contact us today to learn more about how we can assist you in securing your green card through the EB-1 program.
Welcome back, everyone. That was a very informative session on L-1 executive transfers and the important work rights available to L-2 spouses. Ms. Moran, we have compiled a list of frequently asked questions that many people have about today's topic. All right, so our first question is, I have a proprietorship business in Bangladesh. Am I eligible for an L-1 visa?
Okay, so for a proprietorship, that usually means like a sole proprietorship, like one person doing business. So that will not be applicable for the L1. So you won't be able to do an L1 visa for sole proprietorship because those are people who, again, own and operate a sole proprietorship in their own home country. And to qualify for the L1 visa, there must already be a qualifying relationship between perhaps your business in Bangladesh and one in the US. So if you're the owner of a sole proprietorship with no US affiliate or a related entity, you would not be eligible for the L1 visa. But if you want to expand into the US under the L1 visa, maybe you could consider forming an LLC or a corporation for the foreign entity before applying for the L1, and then you could have that clear organizational structure and greater eligibility for the L1A visa.
All right, thank you very much. My next question is, can I start a proprietorship business in the US under an L1 visa?
Right, so sort of similar to the first question, and that you really can't use the L1 visa to start as proprietorship in the US. So it's specifically designed for people to be transferred from the foreign entity to the US. For of an existing foreign business. So you can't come in just to start the sole proprietorship. But if you want to start the US office, you can have that again structured as a corporation, a subsidiary, or affiliate rather than a sole proprietorship. And then you could be able to file for an L1A new office petition to transfer yourself already as an executive or a manager.
Thank you very much. Thank you very much, Ms. Moran, for explaining these complex issues so clearly. I'm sure our audience finds this guidance extremely helpful. Before we wrap up, do you have any final advice for executives and families considering the L1 and L2 visa options, especially regarding planning their transfers and spousal employment?
Yeah, of course. So I would say that if you have any further questions after watching this live, to please contact us, as I think an immigration attorney is the best source of knowledge for this kind of thing. So please reach out to our firm and we'd be happy to help you. And also tune in next Monday for our next live to see our next topic as well.
Thank you so much, Ms. Moran, for joining us today and sharing your valuable insights. It's always a pleasure having you with us.
Thank you so much.
Thank you. All right, so that brings us to the final segment of today's session, our weekly immigration news updates. Thank you, everyone who stayed with us till the end. Before we close, let's take a quick look at the most important immigration updates from this week that you should be aware of. Until next time, this is Ms. Dushari Turin signing off. Stay informed and stay ahead. Have a great day.
Hi, everyone. Welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include border encounters fall to a 50-year low, lawsuit challenges Trump's gold card visa, judge blocks Trump move to end TPS for Haitians, new poll shows Americans increasingly support immigration. Let's begin with the border encounter numbers. Border encounters fell to 237,500 in fiscal year 2025, marking the lowest level in more than 50 years. The decline comes amid tougher enforcement measures in both Mexico and the United States, including stricter asylum rules under President Biden and expanded enforcement after Trump returned to office. Now, a major lawsuit targeting a new visa program. Labor groups and immigration scholars have filed a lawsuit challenging the administration's gold card visa program, arguing that it creates a pay-to-play pathway for wealthy applicants. The program provides fast-tracked immigration for individuals paying more than $1 million, which critics say diverts EB-1 and EB-2 visa numbers away from scientists and skilled workers. The administration defends the policy as a way to increase revenue and attract global talent, while opponents argue that the EB-5 program already addresses investment-based immigration. Next, a major ruling impacting TPS holders. A federal judge has halted the administration's attempt to end temporary protected status for Haitians. The court ruled that DHS did not provide adequate justification for ending the program, allowing deportation protections and work authorization to remain in place while the case moves forward. DHS has announced plans to appeal the decision. Finally, new public opinion data. A new YouGov Economist poll shows rising public support for immigration. According to the survey, 46% of Americans now say immigrants make the United States better off, which is a 15-point increase since early 2025. At the same time, 50% of respondents believe that Trump's immigration approach is too harsh, indicating a noticeable shift in national sentiment. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in U.S. immigration.